Lord, suppose we took the decision that in view of the proviso becoming otious, because there is no constituent assembly, that limitation of recommendation, ultimately it's recommendation. Suppose it recommends that don't abrogate. President is not bound by it. So now the Constituent Assembly, having chosen while being dissolved not to recommend, the Constituent Assembly has left it to the absolute discretion of the President. It could have been done, my lord. Possibly it could have been defendable action, but with a view to ensure that there is democratization of the action. And my lord, your lordships are dealing with the state of, this is a provision which is one of its kind. There is no such provision either in our constitution or in any constitution. So the law which your lordships would ultimately lay down is not going to, Lord, touch upon any other provision. If suppose the Constituent Assembly, while it was being dissolved, if it framed the constitution, it had options. A, don't abolish. I am recommending that President should not exercise powers under sub-article 3. He should not abrogate 370. That was the first option. Second option, he should abrogate Article 370 after 5 years. Till then, let the Constitution continue. Third, the President is, we recommend that President should modify some of the provisions which we recommend and continue 370 as it is forever. Having done nothing of this, the Constituent Assembly goes without making any recommendation and therefore leaving it to the absolute discretion of the President.
Solicitor, you said that the President is recommendation.
It's a recommendation, my lord. It's not.
You see the words used in the proviso. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary.
Yes, Lord. Why I say this, Lord, kindly see the second proviso, where concurrence word is used. Concurrence means I have to say yes, otherwise you cannot do it. Therefore, I am contrasting the word concurrence with recommendation. Consultation, yes. The concurrence is at the highest level. That without consent, concurrence means consent. Consultation may sometimes means consent, may not mean consent. Your lordship has seen Justice S.H. Sheth's transfer of judge's judgment, where it says that consultation can even mean concurrence. So I am not just contrasting the word concurrence with recommendation. That the same provision uses the word concurrence, means unless the state say yes, President can do nothing. But here same provision uses the word recommendation, that you will recommend. Ultimate power with the President who is answerable to the House which is answerable to we the people of India. So highest executive functionary is conferred with this decision, and we can read that in absence of Constituent Assembly and its recommendation, the proviso goes. It becomes redundant. It becomes otious. It becomes not possible of being implemented. And law doesn't require performance of an impossibility. But considering the nature of the strategic importance of the state, it was felt necessary that let this be debated in both the houses of Parliament. And Rajya Sabha is, my lord, house of people. It has its own federal structure. Every state has a representation in a different indirect election form. And both houses passes, my lord, with 2/3 majority. My lord, even Constituent Assembly could have recommended that word temporary be deleted. Even clause 3 be deleted. Why not? There was no embargo. During the subsistence, during their existence, and while being dissolved, or during that period, they could have said that delete temporary provision, delete Article 3. Now we don't want anybody's power to abrogate. They could have said even C can be deleted. Suppose, my lord, the Constituent Assembly were to say that delete 1C, that Article 1 is untouchable. Because now we have our own constitution, we no longer are integral part of India. My lord, it could have said, technically it could have said that. But Section 3 of the Constitution says, no, we are an integral part of India. They never said that President's power under 3, we recommend being either diluted or taken away. They never wanted clause 3 to die. That's very clear.
All right. So we've covered now the first point, the interpretation of 370.
My lord, 370, my lord, there are some points, my lord, if your lordship permits.
So on 370, Mr. Solicitor, why don't you summarize in 3 or 4 propositions what's the heart of your submission? on
Can I, my lord, do one thing if your lordship permits? My lord, I knew, my lord, I'll be running against time. My lord, instead of, my lord, my 40, 50 pages of, my lord, explanation and arguments, I have summarized in 4 pages. It says, my lord, it declares it to be temporary. Your lordships may not read anything, my lord. It is contained in part 21, which has 3 categories: temporary, special provisions, and transitory provisions. So constitutional framers are aware of what word they are using. My lord, second, I have said, my lord, I have already said, and this is, my lord, something very, very serious. Look at the width of the power. 2 individuals in practice, and legally speaking, 2 organs, namely the president and the state government, can alter any part of the constitution and apply it to one part, can delete any constitutional provision, can create a new provision, and therefore, my lord, the submission is, considering the very expanse of this provision, the constituent framers would never have, my lord, contemplated this to remain forever. Such a position can never remain forever, where our constitution remains a floating document perennially for one state. Then 3, my lord, therefore, my lord, I am saying that this also is one suggestive indication that framers never intended it to be permanent. Then, my lord, this is the entire provision. My lord, this is very important. This is the entire provision in the constitution where application of not only constitution, please see this, my lord, the seriousness of this. Application of Constitution of India and application of central laws, including beneficial legislations, is dependent upon concurrence of the state. The only provision. It says it would not apply, it will not apply. Such a, my lord, drastic provision could never have been intended to remain permanently. Then, my lord, this is the only provision which has an inbuilt self-extinguishing provision, sub-article 3. No other constitution provision has this self-destructing clause. This again, my lord, is a pointer that it was intended to be temporary. Then, my lord, it is a goal of equivalence, my lord, I have already said, my lord, in the judgment which I read, that temporary provision cannot be read so as to treat one part of state differently, their citizens differently. Then, my lord, your lordships would not give interpretation to a temporary constitutional provision having such drastic consequences, because your lordships are not going to be confronted with a similar situation in future. There is no other provision in the constitution, and to our knowledge, any other part of the world where a provision of a constitution of the main unit applies only with the state consents. In a federation like ours, there cannot be any such provisions. The unconstitutional provision remaining in the constitution and operating. Unconstitutional, why? It discriminates. It confers an authority which is never contemplated in other states. The very purpose that the concept of recommendation is provided in the proviso, Lord, leads to an inevitable conclusion that they wanted it to leave it an option to the Constituent Assembly during its life to make some recommendation. Otherwise, that proviso goes. Lord,
according to you, the proviso will not govern the substantive provision.
Cannot govern. Yes, my lords are right. I am obliged, my lord. If the proviso become otiose, the main provision does not become otiose. Then the conditionality attached goes. Some decision or lack of it by a different body. My lord, can we read a constitution that president's decision is dependent upon some outside body takes a decision or does not take the decision? If it takes, it's an option. If it doesn't take, you lost your option. The President of India cannot be denuded of its power by either they giving recommendation or at least not in absence of recommendation. Please mark this, my lord. This is what fell from my lord Justice call, that you are putting it at the higher threshold than the basic structure. basic structure cannot be altered by constitutional amendment, but there is no such limitation in 1D. You can, they have chosen not to apply some of the fundamental rights. Meaning thereby, a permanent power is vested on two organs of the state to alter even the basic structure so far as its application to the state of Jammu and Kashmir is concerned. And this is very, very serious. Now, of course, my lord, it can never be done. Now, all are at par. Even if the Constituent Assembly would have been in existence, the limited role stipulated, my lord, that I have already said, my lord, it is only recommendatory, and my lord, President could have taken any other decision.
That may not be correct, actually, because so long as the Constituent Assembly, it was not recommendatory. Look at the way the article is couched. Provided that the recommendation of the Constituent Assembly of the state shall be necessary. So it's not recommendatory in that sense.
Our
Sorry.
constitution always, let's put it very, constitution as a supreme document in a democratic country will always place restriction, whether it's the judiciary, whether it's the president, whether it's the legislature.
Lord,
It's always-
I bow
that's-
down, but
that's-
my submission.
Constitution is governance by limitation, with limitation.
And the use of the words recommendation shall be necessary is a clear indication that it's not merely recommendatory, but that there has to be a recommendation before you exercise.
Can your lordships read it a slight differently? The way, my lord, I read it, what is mandatory, the word shall, that you take recommendation. The recommendation is not binding, my lord. Otherwise, the Constitution would have said that it would and act accordingly. What is mandatory is taking the recommendation. That's another way of, my lord, interpreting.
The other part of the argument, we understand that the proviso, after the Constituent Assembly had done its job, is no longer applicable, but it doesn't affect the main part. We have main clause 3. We'll examine that out.
Or modifying the 370 subarticle 3 by replacing the successor body. We went for the second, which according to me was not necessary. It could have been done without, my lord, any recommendation also.